Hey again, everyone. It's Rob Ryder on Thursday, May 6, 2021. And today is Esquires, our Pilgrim Society puppets in the service of the devil. We'll be shining a light on Esquire's dark deeds. And this is really a continuation of a video I just recently done. It was called Proud Boys, Mr. Patriot Deserves Justice, Not Mercy. Right, and we're going to look at a few more examples of some of these cases going on in the District of Columbia having to do with the alleged insurrection of January 6, 2021. Which technically, if there was an insurrection, it was the people already in the building, because the people who were claiming to be the Congress that were going to sit down and certify the vote, or the electors, right? Well, none of those individuals had taken the oath of office required by the 6th article of the Constitution to be a congressman, to sit there and make any kind of decision whatsoever. Right? They were actually the insurrectionists. We were just taking back the building. So, everybody has their story, right? Well, that's mine, and I'm sticking to it. But anyways, Esquires, repent while there's still time. And here's just two examples out of the Bible where the Lord's rebuking your class, a person. So Luke 20:47 says, which devour widows' houses, he be talking about you, and for show make long prayers, the same shall receive greater damnation. Right? So when they go into court and they do their blah, 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 right? And they end up taking some widow's house, or taking some widow's son's house, so now the son can no longer help the widow mother. Things like that. That's what we're talking about, right? That, yeah, you guys are really good at it. Well, once wasn't enough. It's also Mark 20, chapter 20, verse 40. They devour widows' houses, and for show make lengthy prayers. These men will be punished most severely. Rest assured, I have faith in God. That's what will happen. That's why it's time to repent. Playtime is over. And you heard it from Staff Sergeant Robert Allen Ratluski, United States Army veteran. You can call me Rob Ryder, unless you want to make it legal. And my email address is courtofrecord@aol.com. And there's a phone number. So, yeah, let's talk about the Pilgrim Society just for a second, right? Where did this come from? Well, I'm not going to explain it, but if you go to these people here, right, it's called the American Intelligence Media, which is AIM, AIM, for the number 4, truth, TRUTH.org, aim4truth.org, and go under audios and videos, and they got a list of them, but just go all the way to the bottom, and you'll see them talking about the British Pilgrims have taken over America. And in here, one of the things they're bringing up is that a guy who is the deputy prime minister of the United Kingdom is over here basically running Facebook. Right? He's the one in the background making all the freaking decisions, and they got, their puppet in front of them facing the media, right? Or speaking for the media, speaking for, is it Zuckerberg? Is that him? Yeah. But, basically it's being run by the Pilgrim Society, which is all the high muckety-mucks of the English system, whether it's in the United States or in England. Like, there's two branches of it, right? But they're the ones behind all this simulated legal process shenanigans that we've been enslaved by. And, they're agents to do it. They're puppets. Well, not just Esquires, but Esquires are one of them. And, you could go further and say, well, basically anybody who is of the professional class could be thrown into this bunch of puppets in service of the devil. So, like, take a physician, for example, right? When a physician takes the Hippocratic Oath, that oath is actually written to Greek gods, right? And the oath is not to give up the secrets of your patron or of your teacher, master, whatever you want to call it. Right? Just look up Hippocratic Oath and go read about it in Wikipedia. Go find the historical beginnings of it. And now it's been changed, right, for today's, for today's uses, but they didn't change the meaning. They just changed the way it was written. And so if if you're swearing an oath to Greek gods, well, that'd make you a blasphemer. And it goes on and on and on. So enough on that. Let's just deal with the things that we can deal with, right? We'll leave all the rest to other people. Everybody has their own thing they can do in this problem. That's only God can do everything. But we have the power of God, and what he did is he split up little pieces between people, right? So that we have to work as a group to get something done. Can't do it as an individual. That's why the devil wants us to be individuals. It's much easier to pick you off one at a time than it is to pick off a group. And so here we are. Okay, hang on a second. I'll be right back. Before I forget, in this same section, another very interesting video. I mean, there's probably quite a few interesting ones in here, and I haven't watched them all. But one that I do remember watching is this one here, the Spear of Destiny, which is actually the Lance of Longinus, which these guys are saying that they've actually believed that they have seen and examined the true Lance of Longinus that pierced the side of Christ. And the one that Hitler was after, that was in Austria, which was part of the papal jewels, that he took when he overtook Austria, and he took it into Germany and built a, cathedral for it or whatever the hell he did. That was not the original. It may have been a close copy that had actually been put in contact with the original. That's how they did it back in the day. So it's like a secondary sacramental item. But the true Lance of Longinus, they believe that they had here just recently examined. So if you're into that kind of stuff, I suggest you watch it. All right, back in a minute. And just to clean up a few more things. So what I'm going to do today is some more cases that have to do with Proud Boy persecutions in the District of Columbia. And so, I'll be looking at court cases and looking at the documents in there and pointing out their errors, right? Which I had done again in a couple other cases, just in case you think it's a one of a kind. Well, it's not. It happens all the time. I did it in Alex Jones is Alexander Emmerich Jones, not Alex Jones et al. And also in Newport News is an alien, enemy belligerent. Can't change their spots. And then again in Persecuted Oath Keepers. So all these have something to do with court cases that, documents will show you that there's some shit going on behind the scenes that, actually it isn't going, it's blatantly right in front of you, and they're getting you to agree to be a fiction and go to a private court run by Judge Judy, who's, some attorney impersonating a state judge or a federal judge. And they're not either of those because they didn't take the proper oath. Right? So if you didn't take the oath, you don't have the authority. I don't care, how many titles you got behind your name or how nice a suit you wear or how fucking clean your teeth are. Right? You're going to be chastised. The Lord is going to hit your ass with with a rod of iron and crack your pot. And it's just around the corner. Okay, so in the Proud Boy, Mr. Patriot deserves justice, what did it say? Not pity, cheapers. I was showing that, here's the case where it was against a Dominic Pizzola, right? And we were going to take a look at his indictment and so forth, and I was going to point out all the things that were wrong in it. And one of the things I had noticed when I did it was that this particular attorney had made an appearance of counsel for the defendant. Or one of the defendants. This had multiple defendants in it. Well, as it turns out, the same attorney's in another case that I looked at that we're going to get to in just a second. But when I had seen this case, and I went and I said, I'll try to do something. I'm going to write a petition, verified petition. That's what I'm going to call it, for redress of grievance and I'm going to send it to the court using the system that they have available because it's COVID season, right? And you can't go into court. So they've made provisions to file paperwork by email, even if you're not, an attorney using the PACER system. So I said, okay, I'll do that. So you can see the dates. It was the end of April. And so just to give you an idea, if you haven't watched that video, what the things that you would find if you were paying attention to the paperwork were these. I was writing it to the emergency judges, right, that this particular case ongoing at the United States District Court, District of Columbia, right? Now that's the name of the court. You look online. It doesn't say for the or in the, or it's just United States District Court, District of Columbia. Is a simulated legal process orchestrated by Esquires impersonating as United States Attorney for the District of Columbia that deprives the alleged defendants of life, liberty, or property without due process of law, in offense of Amendment V, the Fifth Amendment, to the Constitution of the United States. And in that amendment, it says that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when in actual service, in a time of war or public danger, or shall any person be subject to the same offense to be twice put to jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That, covers all sorts of things, right? So number one, it has to be a proper indictment or some other presentment, which I guess could be a complaint or, as they like to call it, a information, right? That there could be other ways, except if you're under some kind of militia government, right? And, well, myself, I believe that's what it is. That's what the gold fringe flag represents. No, it's not Admiralty. It's Army. Go read Army Regulation AR 840-10, Section 3 of Chapter 2. It'll tell you all you need to know about the gold fringe flag. And then go look at a fucking Navy boat and tell me if it's got a gold fringe flag on it. No. It's not flying a gold fringe flag. But the Army carries the gold fringe flag. Hoorah. Sorry there. Hoping I don't get too many Marines mad over me for, stealing their thunder. Anyways, utilizing PACER to search for and view the various documents filed in this case, the petitioner has verified that the indictment filed as document 12 on January 8, 2021, and the first superseding indictment filed as document 34 on 4/16/2021 were not signed by the foreperson, right? The foreperson of the jury is supposed to sign the damn indictment after, as part of doing the indictment. And were endorsed a true bill, which is a simulation of the phrase true bill, required to be endorsed on a bill of indictment and signed by the grand jury foreman. Bouvier's Law Dictionary, 1856 edition, defines true bill as these words, what words? These words, true bill, are endorsed on a bill of indictment when a grand jury, after having heard the witness for the government, are of the opinion that there is sufficient cause to put the defendant on his trial. So unless you have an indictment signed by the foreperson endorsed as a true bill, then you haven't given cause for there to be a trial. Right? And the defendant is entitled to know the nature and the cause of the charge. Well, there can't be any cause unless there's a true bill indictment. Right? So calling it a true bill is simulating that it's a true bill, but that's not the proper term. And, we'll be looking at one again, and you'll see that they don't sign foreperson, and they, there's no signature, and they put a true bill. So these bad faith filings simulate a bill of indictment and cannot be construed as the indictment of a grand jury required by Amendment V of the Constitution of the United States. Document 12 was subscribed by an individual claiming to be Channing D. Phillips, acting United States Attorney in and for the District of Columbia, while document 34 was subscribed with the mark of someone claiming to be United States Attorney in and for District of Columbia. Said mark appears to be Michael R. Sherwin with a scribble, which is probably supposed to be his initials, but who cares? Right? It didn't have anything for the foreman on there, but it had, some little bullshit at the bottom about a stamp with somebody's scribble. And they're claiming to be, United States Attorney in and for the District of Columbia. So take notice, emergency judges, there is no such office in the government of the United States with the title United States Attorney in and for the District of Columbia, acting or otherwise. And the United States does not recognize the use of initials in place of names when the name is used for identification of an individual for official purposes with the United States government. See the Real ID Act, right? The Real ID Act, that's the act that, was supposed to have gone into effect in 2020 that said if your, driver's license didn't have certain things on it, you couldn't use it to get onto an airplane or, to really get into any federal facility whatsoever. And you're going to have to go get one of those, passport cards or something, right? But it said for it to be Real ID compliant, right, that what it had to have on there is your full legal name. And it defined your full legal name as your first name, middle name, last name, or surname, no initials, no nicknames, right? So Michael R. Sherwin, well, that's certainly an initial, so this is not that man's full legal name, and it cannot be used for official purposes with the United States government. And here we are talking about an indictment in a fucking federal court. Well, that just ain't going to make it, right? Shine a light, shine the light. So anyways, continuing, does not recognize the use of initials in place of name when the name is used for identification of an individual for official purposes of the United States government. Under the laws of war, their concealment of their full legal name is the act of a spy. It's right out of the frickin' Department of Defense's Law of War manual, where they're defining in Chapter 4 all the different classes of persons, whether protected persons or unprotected belligerents. Continuing, the subscribers are concealing their true identity while pretending to be an officer or employee of the United States in order to usurp the authority of an office of the executive branch of the government of the United States as part of an effort to coerce the civilian population of the United States and influence the policy or affect the conduct of the United States government by coercion. And that little blah blah right there, that's the definition of a certified act of terrorism, right? That if the Secretary of State says it's that, right, then you could, and you had general liability insurance, you could go put a claim in against your insurance company for an act of terrorism. Usurpers have even concealed the full legal name of the alleged defendants and appear to be using numerous Esquire conspirators to act as legal counsel for John Doe defendants. The simple fact that the alleged attorney of record in this matter has not objected to these false indictments is proof of collusion with enemies of these United States impersonating as officers of the United States. Petitioner prays emergency judges do their duty to God and country and end this malicious prosecution of patriots this day and see to their relief, and then have the usurpers arrested. I verify under penalty of perjury the foregoing is true and correct. Yes, I did. Well, I sent it in, and haven't complied. So this is where we are now in that particular case, right? This is, Pizzola. All these different attorneys. So, right? Dominic's got 1, 2, 3, 4 attorney firms involved. Pepe's got 2 attorney companies involved, or whatever you want to call them. and then the plaintiff has got 2. And so, right, all these attorneys are making money on this deal. This is big business for them. This is why they want to have all these cases, because they're all charging hours. Well, this John M. Pierce, he's on this case, but he's also on the next case I'm going to look at. And so I had sent this on April 27th. I did the video on May 1st. And then what happened next is what we're going to talk about. So hang on just a second. Just one last little detail about this case with Pizzola. Right there, here's all the docket entries. If you go all the way to the end, the last one was leave to file denied. Verified petition for redress of grievance as to Dominic Pizzola. Right, William Joseph Pepe and Matthew Green. This document is unavailable as the court denied its filing. Leave to file denied. The captioned case is a criminal case, and this individual has no right to file a document in this matter. Signed by Judge Timothy J. Kelly on April 30th, 2021. So, I didn't get it into the docket, but I made them have to admit they had the damn document, and, they were going to make a decision not to put it in. Well, why would they do that? Right? They're going to say because I didn't follow a procedure, they're going to allow people to be tried under documents that simulate a legal process. Well, that's just evil as hell. That's what Esquires do best. So, okay, well, since then, right, because I'm on the internet all the time, I get all these news articles that pop up on my screen. And there's one about a National Guard soldier, his 4th service member, charged in Capitol riot. Right? It's like, well, now they're going after people that are in the service, not just veterans, but, people in the service. And so I can't do a lot about this particular case because there's not many documents in the case yet. But I need to say, if you're a member of the service and they're putting service members and arresting them, you need to demand trial by court-martial. You don't have to answer these fucktards. So now I demand trial by court-martial. I'm in the military. Right? And go bark at your frickin' commanding officer all the way to the top. Use the chain of command and don't stop until they agree that you are privileged to trial by court-martial. Because a trial by court-martial will protect your due process rights. But the shit they're doing here has nothing to do with protecting your rights. It just has to do with persecuting you. Right? And I need to tell you, Esquires, if you're really starting to fuck with people in the military, you're about to get hit with a rod of iron. Right? Because I heard General Milley say he will protect the United States, and that includes the fucking armed forces. So please, if you're in the military and this is happening to you, start bitching. Right? It is the right of an enlisted man to complain. Right? Your God-given right. Start complaining. It doesn't matter what they say. Go find the book, find what it is you're going to stand on and point at it and say, yeah, but the book says this, sir. And they have to listen to you. There's nothing they can do. They're just waiting for you to do that. Right? And so I'm just going to, I'm just trying to give you evidence of things to look at to go point at. Because you don't need to have 10 things, just need to have one. So yeah, anyways, this was, a particular a soldier in the Wisconsin National Guard was charged Monday in connection with a Capitol riot on January 6th. Was it ever declared a riot? You know the reason they want to use riot? Now, here's an interesting thing we're going to see is that the democracy has jurisdiction over things to do with public peace. So riot, disturbing the peace, disorderly conduct. Those are the kinds of things that they can charge you with, right? They're going to hide they're going to hide that fact and all these other words they use. But at the end of the day, that is the thing that they have jurisdiction over. And I need to pull something up to show you an example. So give me just a second. So in Michigan, now this is on the state level. We're going to be we are going to be looking at federal in just a second. Right? Well, this is supposed to be the state level. So in Michigan, they have this information form used for felonies. who's the victim or complainant and complaining witness and the people of the state of Michigan versus, da 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 da. Well, first, if you were to look at one of these, then it says it has all these blanks, then every blank must be filled, or there must be an NA in it to show that it wasn't forgotten, right? That it wasn't missed. Well, if you were to look at somebody's when they're done, they have, all sorts of blanks in. That's a secondary thing. But then it goes on, and they're supposed to put in here all the things that you did, start writing what you did wrong. But it doesn't matter what you write in the blank. At the end of the day, the last thing it's going to be is and against the peace and dignity of the state of Michigan. Well, that would be disturbing the peace. That's what's going to give them authority. It doesn't matter what kind of stuff they put up here, right? It doesn't matter at all. They're going to get you for disturbing the peace. It's written on the form. Well, that's how they do it. So now I'll show you shortly how they're doing it in this particular case we're going to look at. That would have the same effect. So hang on. And by the way, that form is MC 200, right? It's Michigan compiled laws are approved by the state court administrator's office, right? And so you can Google MC 200. You can look at it yourself, and there it says it right there, and against the peace and dignity of the state of Michigan. And it's an information, right? So this isn't an indictment, but this is the other thing that can be used. Besides an indictment of a grand jury for a felony, you can use an information. And I'll show you how they're trying to do that in this case. Okay, and in the case of the National Guardsman from Wisconsin, Abram Markovsky, right, they issued this arrest warrant. I'm sure that Abram has a middle name, so let's start there, right? That isn't this man's full legal name, right? That's not the name he signed up to serve the military under. Or if he did, he did. I'm just saying, I bet you he has a middle name. And so they're hiding his middle name. So this isn't him. They've taken the person, Abram, middle name Markovsky, and turned it into a thing. So it's almost like saying now it's a John Doe. We're not really identifying who the defendant is, other than a John Doe, by using a different name than John Doe. But it's not an individual's name. It's not on his birth record, and it's not on his real ID, compliant ID. It's not on his military ID. Anyways, they're going to go arrest him. Say, Abram Markovsky, John Doe, we're going to come arrest you under a complaint and say that you did all these things wrong here. And it's going to be issued by Robin, using the middle initial Merriweather, who claims to be a U.S. magistrate judge, but there is no attorney licensed to practice or that's passed the bar that is named Robin M. Merriweather, so there cannot be a U.S. magistrate judge named Robin M. Merriweather, but they did it anyways. See right here, violent entry or disorderly conduct. Right? That's what they're going to get him with. Disorderly. They're going to get you for disorderly conduct. But it's not an indictment, and it's not an information, so it can't be used for a felony. Right? Because it said for infamous crimes, you had to have a presentation or an indictment from a grand jury. So, is an information a presentation? Is a complaint a presentation? It's all these word games they use. So this is an ongoing thing that we'll get into more as this goes on. The other thing I want to show is that apparently this is being done by a special agent. Now, does the FBI actually have special agents? Is there an office in the FBI called special agent? Or is it just an agent of the FBI? Right? But regardless, whoever you are, if you claim to be a special agent, well, let me see your oath of office. Right? It should have been filed with the FBI. Where is his oath of office? And there won't be one in the name of Brian P. Blake. So, Brian P. Blake is not a special agent of the FBI. It's a spy using that pseudonym to, persecute a service member of the United States military. It's messed up. Okay, but another case going on in the District of Columbia that we can take a look at, because there's more information to be found on PACER for it, is the case against Christopher John Worrell. Although this would be about the only place they call him Christopher John Worrell. After this would be just Christopher Worrell. But as you can see, Christopher John Worrell doesn't have a date of birth. Right? So, does that mean he's dead? They went through the trouble of putting a date of birth here and then putting X's in. Right? So, apparently, you need to have a date of birth to authenticate which Christopher John Worrell we're talking about. But they don't have one, so we haven't really identified the Christopher John Worrell, the individual human being on the face of the earth that we're talking about. We're just kind of like. Right? And then the complaint says on or about on some date, January 6th. Well, either it happened on January 6th or it didn't. You can't hold me for something that didn't happen on a particular date. Right? Because you say, well, actually it was January 7th. I can say, well, I wasn't there January 7th. I was there January 6th, but if you're talking about having January 7th, I wasn't there. Or January 5th. Right? What date is this supposed to have happened at? Nevertheless, we're going to, charge them with this. Hey, here's that disorderly conduct again. And so in this particular case, the reason this ties into the last video I did is I was trying to get the case dismissed because I had a bad indictment. And in this case, I'm going to show you documentation now where the defense attorney is trying to have the indictment thrown out because it's a bad indictment. But he's not trying to have the case thrown out, just the indictment. So I just kind of think it's funny that the attorney, this guy here, right, in the case we looked at earlier, and I did a video on last week. So John M. Pierce, right, he's actually the attorney for this case, right, where they're going to be adding John M. Pierce as active member in good standing of the State Bar of California. Right? So he's defended in another case. Well, he's the one that filed the paperwork asking for the indictment to be thrown out. We'll get to that in a second. But just trying to make sure I've tied all these. Why are you talking about these certain things? Okay. So this is how they do it. Digitally signed by G. Michael Harvey. He's supposed to be a U.S. magistrate judge. Well, again, they don't have middle initials. I'm afraid it can't be. By Alexander Grandy, special agent. Of what? And how do you prove that you're a special agent? Can I be a special agent? If you don't have an oath of office and you call yourself a special agent of the FBI, then can I call myself a special agent of the FBI? Fill out a criminal complaint, have a freaking U.S. attorney, put a seal on it, have somebody arrested? Let's game on. Let's go. But this is the complaint that he put in. And with this complaint, he put a statement. Right? And right off the bat, he's saying, you're affiant, Alexander Grandy. Well, if you're an affiant, that would mean you're doing an affidavit. And this isn't an affidavit. This is a statement of facts. And not only is it, not an affidavit, it's not a sworn statement of facts. It's just a statement of facts. And, there's a big difference because a sworn statement would look something like this, right? Sworn statement. This is the one that the Army uses. Where you, put who you are and then you give your statement. And at the end is where you do an affidavit. So there is an affidavit in the sworn statement, but you're not filing a sworn statement. Or, you're not filing an affidavit. You're filing a sworn statement with an affidavit. And this particular affidavit, because it's military, when it comes to the person administering the oath, they're going to ask, by what authority do you administer oaths? And if you have a gold fringe flag, that's the authority of the military. And this is why I'm saying that, we should be able to use this form and go to these places that you may not think of, like a church, which has a gold fringe flag. And, I showed in videos that the church got a commission from the military in 1917, or I guess it was actually 1918, right? All the churches the Catholic Church by itself, and then the Protestant churches by themselves as a group, and then the Jews by themselves, each created civil entities, and those civil entities were given a commission by the War Department, not by Congress, right? And that commission hasn't gone away. Now, the unit may have been mothballed, but it doesn't mean it went away. It's still there. The military doesn't, disband anything. Well, I got to be careful what you use your words, right? They don't make it go away completely. It's still there. And so if you belong to a church congregation that has a gold fringed flag, then you should be able to go to that pastor and say, look, I need you to be my administer an oath. Right? Because they have the authority. It's just like them doing a marriage. Right? They do civil paperwork. They do marriages. So there's no reason I'm saying that they couldn't do this for us. Now, I haven't got them to do it yet. I'm just pointing out this is a sworn statement. Your statement with an affidavit. And what we're looking at by this alleged special agent, right, is just a statement of facts where he calls himself your affiant, which has to do with somebody who's, filing an affidavit. So I don't really care what he had to say. I'm just saying this is what it's all based on. And, all this stuff is online. You can go look it up yourself. It's case 121CR00292 on Pacer for the District of Columbia. Get to the end here. All right, Alexander Grady, Tax Force Officer, FBI. Well, by what authority? Right, again, you're a affiant. Now, they say he attested to it, attested to by applicant in accordance with the requirements of Federal Rules of Criminal Procedure 4.1 by telephone on some particular date. They have to prove that to me. So, but that's, what was supposed to have been the vehicle to create a arrest warrant, right, for Christopher John Worrell. Now, they don't have anything about his date of birth. Again, I'm saying it's a complaint. Complaining about these particular statutes. And, it's not by indictment. It's not by information. It's done by complaint. Well, does complaint satisfy Amendment V of the Constitution, the Fifth Amendment, where it talked about indictments and, they use a particular word, start with a P, and I can't remember it. Presentation, presentment. Okay. All right, so we'll just continue on. We're almost to the part I want to spend some time on. Here's the appearance, right? So this is that John M. Pierce. Now he's making money on 2, 3, 4, 5 different cases. But what is he doing? Right? Because here, the defendant is Christopher J. Worrell. Right? He's not defending Christopher John Worrell. He's defending Christopher J. Worrell. And the plaintiff, United States of America, that's a problem too, because the United States of America is a foreign jurisdiction to the United States. Right? They have this thing called this unsworn declaration under penalty of perjury that you can use on paperwork, right? It's under Title 28, United States Code 1746. And it gives two different, ways or reasons for using it, forms of using it. So one is if executed without the United States, and the other one is if executed within the United States. All right, so if it's without the United States, then it has to do with under the penalty of perjury under the laws of the United States of America. Right, but that isn't in here. If it's in the United States, there's nothing in here about the United States of America. So the United States of America is a foreign jurisdiction to the United States. And so how is it that a citizen of the United States is in a court outside of the United States while, being in the United States? Because, the United States got lots of different definitions. A lot of people want to jump on and say, oh, that's a foreign corporation. Or the United States is a corporation. actually, what they're trying to say, and the way it's actually written, is that there's three different, in this particular definition, there's three different things that are the United States. One's a federal corporation, one was an agency, and the other one was, I can't remember what the other one was. Instrumentality, I think. Right? So a federal corporation is the United States. Not that the United States is a federal corporation, but a federal corporation is the United States. It's wordplay. But back to this, right? So when they say United States of America is the plaintiff, that's a foreign jurisdiction to the United States. And yet, that's who the plaintiff is. So, the plaintiff isn't the government of Christopher John Worrell against him. It's the United States of America, a foreign jurisdiction against him. Appearance, notice of appearance. Is this somebody else? Yeah. Right. Now, this guy, he's for Christopher Worrell. Right. So we got multiple attorneys for the same guy. One for Christopher J. Worrell. One for Christopher Worrell, but none for Christopher John Worrell. Christopher John Worrell's not being represented. And all of that ended up creating this indictment, right? That, now the indictment is for Christopher Worrell. It's not Christopher John Worrell. It's the United States of America, not the United States. It's got some magistrate number on it. Actually, I got this marked up. So this way, you look online and see it. It's all just real quick, right? This is what the indictment looks like. Really not much to it, but, when you mark it up, you can find all sorts of things that you might want to question, like there's no criminal number. It says criminal number, but they didn't put one. Well, what's the criminal number? Right? The defendant's name isn't proper. I say the plaintiff's name isn't proper. This has got some magistrate number, but this 21 MJ 296 is not the same case as 21 CR 292. All right, so how come this piece of paper was filed in this court case? Right, where's this case at? The grand jury says that on or about January 6th. Well, I'm afraid that's not specific enough. Either it happened on January 6th or it didn't. All right, so either on January 6th or about January 6th, but not on or about. You have to take a pick. And they picked the wrong one, and you can't defend yourself with that. Within the District of Columbia, Christopher Worrell, right? That's not his full legal name. That's like saying to John Doe, did lawfully and knowingly enter and remain on restricted building grounds, blah, blah, blah. We're going to go through these counts. Count 2, count 3, right? They're all on or about Christopher Worrell, not his full legal name. And, in this particular case, count 5 is a civil disorder. Well, that's the same as saying disturbing the peace. That's like that part that was outside of the block on the Michigan felony form. Right? Doesn't matter what else we're going to say you did. At the end of the day, at least one of these is going to say that you're violating, that you were disturbing the peace. Right? But there it is, a true bill. Not true bill, but a true bill. That's not the proper term. The proper term is true bill. Right? The foreperson didn't sign it. But we got Channing D. Phillips, who was the same guy on another one we did, who's saying he's the attorney of the United States in and for District of Columbia. Right? That's not the proper name of the office. Actually, I think it's United States Attorney for the District of Columbia. I believe that's the proper name, but, this is not the proper name of any office of the United States government. I mean, this kind of stuff is so simple. I could show this to a private and say, now, private, if this and this and this isn't done right, then, have this man arrested. Right? I mean, as people came to the checkpoint, and private would check their papers and see this shit was wrong, well, then, hey, arrest this man, and it would happen. Right? That's all we're missing. We just don't have that connection between this is wrong. Military, arrest this man. And when we get that, well, this shit will stop. But until then, they have no reason to stop because it's been working for a long time. Right? They're just going to the thing they know best. So this is, right? Again, this was the indictment. And so, some number of documents later, all of a sudden this defendant's motion to dismiss the indictment as defective is filed by, who's the guy? By John M. Pierce. Right? And, there we go, John M. Pierce. So, when I first saw that, oh, hey, because you look at the dates, this is May 4th. This was after I put the video in. After I put the petition in, which I did on the 27th, into a case that he's the defense attorney of. He may know something about what I had done, and I thought, well, he's going to try to help the guy out. That was the first indication that this bar card attorney was trying to do the right thing. However, when we start looking closer, you'll see that the Esquire's intention is to dismiss the indictment, but not the case. He's just going to say the indictment is wrong. But if you remember in the Article 5 there, you can have a presentation or a bill of indictment. And, again, that's the proper name. It's called a bill of indictment. It shouldn't just be called an indictment. It should be called bill of indictment. That's the common law name for it. Okay, so it's United States District Court. Now, if you go on the court's website, it's just United States District Court, District of Columbia. There is no for the in there. They're not taking it to the court that's on the website. It may, this may be happening in the same building that court's supposed to be in, the United States District Court, District of Columbia, but that isn't the court where this is going to. And this is the thing about when they do swearing in for citizens at the courthouse, or at the federal courthouse, that the Department of Justice is just renting a room. It's really not the district court doing it. It's just being done there by the Department of Justice using a room in the district court of whatever, district you're in. But it's not being done by the district court. It's not in the records of the district court. Right? Your naturalization records are not in the district court where they are supposed to be. At least not that court. Right? Not the one where you went and swore your name to or swore your oath to. I'll continue on. I say United States of America is a foreign nation, and I know that Christopher Worrell is not this man's full legal name, and that this number here does not match this number here. Right? It doesn't have a 1 in front of it, so it's a different case. Defendant's motion to dismiss the indictment as defective. The defendant, Christopher Worrell, again, not his full legal name, by and through his counsel, tenders his motion to dismiss all charges within the indictment as defective for lack of specificity and failure to state an offense. Right? Didn't state a claim upon which relief could be granted. He didn't get the nature and cause of the offense. Right? A brief in support is being submitted simultaneously with this motion, and a proposed order granting the relief requested is also tendered. Well, it sounded good to begin with. We're going to see they didn't put a brief in, they put in a memorandum. And, there's a document called a brief. It's common law to use a brief. So brief has a definition, and so does memorandum. And they said they're going to file a brief, and they didn't. They filed a memorandum. So, we got at least two attorneys eating off of this one as the defendants of this guy. So you can see this is it's the pigs at the slop house. They're just eating it up, pouring money out to them. They did the same thing with the COVID shit to all the pharmaceutical companies and the medical professions of all kinds, the hospitals. They all made their gads of money, and now it's the attorney's turn. All these professions, I see, are being run by the Pilgrim Society, and, It's all being controlled by the devil. So, a certificate of service. I hereby certify. Well, I is unidentified, so nobody's certified. Somebody's committing perjury saying that they certified something because there is no John M. Pierce. There's no signature block that he's an attorney or anything else. There's none of this on there. And this is a completely separate piece of paper, so who's to say what this goes to? All right, it doesn't say what he's filing. It just, it's a very generically written document that would make you think that they're putting in a certificate of service. But what they're actually putting in is just a bunch of bullshit on paper that means absolutely nothing, and they're not signing to it. Memorandum in support of defendant Christopher Worrell's motion to dismiss the indictment as defective. Right? To dismiss the indictment as defective. Not to dismiss the case, just to dismiss the indictment. All right? Just evil as hell. Again, wrong. It's all wrong. Table of contents. Okay, let's see what we do next. Now, this might be of use. I mean, they have all these court cases where these are the authorities for whatever they're going to use as their justification. But here's how it started. Right? Defendant Christopher Worrell. And then they go to call him Mr. Worrell. And that's where I knew it. So, you fucker, you must have watched the video. All right. In fact, let me show you that real quick. Just take it. This was the cover sheet to the video, Proud Boy, Mr. Patriot deserves justice, not pity. Right? There's the Mr. Now it's Mr. Worrell. But if you go and you look at the definition in Wikipedia for Mr. MR, right, it says in the 19th century and earlier in Britain, 2 graduations of gentlemen were recognized. The higher was entitled to use Esquire, usually abbreviated ESQ, which followed the name, and the lower employed Mr. MR before the name. Today, on post from Buckingham Palace, a man who is a UK citizen is addressed as Esquire, ESQ, and a man of foreign nationality is addressed as Mr. MR. So an MR, right, doesn't have any rights because he's a foreign national to the jurisdiction that Esquire's in, but they both fall under the graduation of this term called gentleman. And way back in the day, I did this video called Don't Call Me Mr., which is why I make them call me Staff Sergeant. Don't ever be a Mr. That's, I'm not a Mr. I'm not in your jurisdiction. But that the first use of the term gentleman was used, this is common law, way back in the day, 13th, 14th century, to describe a man who had paid, others to hack his neighbor into pieces. And they called him a gentleman. Right? So, and in that group of gentlemen, you got Esquires and Misters. Esquires are in the nation, and Misters are out of the nation. So, you have no jurisdiction, you have no rights in their jurisdiction, which is why they want you to be a Mister. And sure enough, they're just making my point. We're going to call him Mr. Worrell. Buying through a counsel pursuant to some Rule 12 of whatever, right? Doesn't even say what it is. Rule 12B, da-da-da-da-da. Now, we can assume that that's the federal rules of criminal procedure, but it doesn't say that it is, so I'm not going to assume that. I'm going to assume that this is a defective piece of paper just done intentionally this way to simulate a legal process in order to persecute someone. So Mr. Worrell, because of lack of sufficient specificity, Mr. Worrell moves the court to dismiss the indictment as to counts 1, 2, 3, 4, and 6, right? Not 5, for failure to state an offense, as pepper spray, gel, as a matter of law, is not a deadly or dangerous weapon. Okay? Because that's what a lot of this had to do. The guy had a can of pepper spray. So they're saying it was a dangerous weapon. Well, this attorney is saying, according to law, that's not the case. And that part's probably true. Right? But how come he didn't say 5? Right? It's just 1, 2, 3, 4, and 6. Finally, Mr. Worrell moves the court to dismiss at least 2, right? So counts 1, 2, and 5 because they are multiplicitous, which means, I guess, they're the same. So then, how come 5 isn't up here with the rest of them? Because you could dismiss 2 like 1 and 2 and still not have dismissed 5 because they are multiplicitous, as well as 2 of the counts, 3, 4, and 6, as these counts are likewise multiplicitous. Right? You can see in those 2 groupings there is room that you could leave 5 out of the mix. So it was done that way intentionally. They could have just said all charges, but they didn't. So, and they're trying to dismiss the charges on the indictment, on the indictment, but not necessarily on an information or something else. And then we got all sorts of factual background, which I'm not all that interested in myself. I mean, it could be interesting to read, but when you're trying to find out, well, what's going on, what matters is looking at the first few pages. What started it and what ended it. And this is document 45-1, so, where's document 45-2? 45-3. At least look at the ones I did. So this indictment does not include specific factual allegations about Mr. Worrell's conduct as it relates to the charges. Rather, the indictment really restates the language of the statute, which is basically what it is. They put down a statute number, and then they write what the statute says, and they say that's what you broke, but they never tie it to you. A criminal defendant may move to dismiss an indictment before trial based on a defect in the indictment, including lack of specificity and failure to state an offense. Well, I'm not happy just having the indictment dismissed. I want the case dismissed. Right? Then they can't try you again for the same thing. But unless they dismiss the case, then they're just going to come back with another piece of paper and say, okay, well then, disturbing the peace, number 5, all by itself on another piece of paper. In ruling on a motion to dismiss for failure to state an offense, the district court is limited to reviewing the face of the document or the indictment, and more specifically, the language used to charge the crimes. Okay, well, that's specifically, but generally they can look at the face of the indictment. And if we look at the face of the indictment, right, we can see that, well, it's a foreign jurisdiction where they've stole the guy's middle name, so now it's a John Doe. He's being tried as a John Doe, right, under a case that doesn't match the case that the paperwork is put into. They're saying it's a different case, got no criminal number, right? It's on or about. That's the part that isn't specific or not enough. His name isn't specific enough, right? But that isn't what he picked out. Well, of course not. But nevertheless, it's interesting, because they chase down these different phrases that come out of these court cases. So an indictment is sufficient if it first contains the elements of an offense charged and fairly informs the defendant of the charge against which he must defend, and second, enables him to plead in an acquittal or conviction and bar of future prosecutions for the same. Well, that seems to me what we should be doing, asking for an acquittal. Right? The notice requirement is established in the 6th Amendment, which provides that in all criminal prosecutions, the accused shall enjoy the right to be informed of the nature and cause of the accusation. Well, that can't happen because the cause was determined by there being a properly done indictment, so there can't be any cause. A valid indictment also preserves the 5th Amendment protections against abusive criminal charging practices. Specifically, it guarantees that the criminal defendant can only be prosecuted for offenses that the grand jury has actually passed up upon. And the defendant who is convicted of a crime so charged cannot be prosecuted again for the same offense. I really don't understand how that is. Grand jury has actually passed up upon? What does that mean? They decided, no, that isn't something we want to charge? And so we can? What is passed up upon me? Is that a legal term? Term of art? And and that the defendant who is convicted of a crime so charged cannot be prosecuted again for that same offense. Well, how about if you charge me for an offense and I wasn't convicted, but I was acquitted? Can you charge me again? Right? This is why they're not asking for an acquittal. They're just trying to get rid of the, indictment and go back to an information or the complaint that was filed in the first place. Because that's what the guy was arrested under, a complaint. He wasn't arrested under an indictment. It's just simulating a fucking legal process. See, here's an arrest warrant. They didn't arrest him on an indictment anyways. They arrested him on a complaint. And so they're going to go back to the complaint. They say, okay, we won't use the indictment. But he wasn't arrested for it in the first place. Devious people. Devious. An indictment must be viewed on the whole, as allegations must be accepted as true in determining if an offense has been properly charged. Well, nobody signed the indictment. Oh, that would be the other thing. Let's look at the face of the indictment. All right, that's what they said to do. Look at the face of the indictment. Well, if we go all the way to the end, we can see that it wasn't signed and there's no four-person signature, and it's a true bill, not true bill. With somebody's claiming an office that doesn't exist in the United States, and they're submitting this into court, and this is what they're going to try to put somebody in prison under. Okay, we're about done here. Just give me a couple more minutes. The indictment against Mr. Worrell is defective for multiple reasons. Yes, it is. On or about January 6th is not specific enough. Spray powder is not a deadly weapon. When considering the four corners of the indictment, the face of the indictment, and the language of the charges, the indictment is defective in violation of Federal Rules of Criminal Procedure, Rule 7, and Mr. Worrell's Fifth and Sixth Amendment rights. Okay, and so here's where the gotcha comes in. It's that Rule 7 they're talking about, where it says in Rule 7, the indictment and the information, when used, a felony, an offense, other than criminal contempt, used must be prosecuted by indictment if it is punishable by death or by imprisonment for more than 1 year. Misdemeanor, an offense punishable by imprisonment for 1 year or less, may be prosecuted in accordance with some other rule. Waiving indictment. An offense punishable by imprisonment for more than 1 year may be prosecuted by information if the defendant in open court and after being advised of the nature of the charge and the defendant's right waives the prosecution by indictment. Well, that's basically what they're doing with this document. Is they're waiving his right to be tried by indictment because it's defective. Instead of saying, when they say that they use a particular word, I gotta start remembering to use, which was acquittal, right? An acquittal. That's what they should be asking for, is acquittal, not just to get rid of the frickin' indictment. Right? According to Rule 7. Let's go on. The language in the indictment exactly mirrors the language of the statute, but is not supplemented with enough detail to apprise the accused of the particular offense at which he is charged. Right? No nature and cause was given. The indictment does not describe the what, where, or how of Mr. Worrell's conduct that led to the charges. Indictment is defective. Charges 1, 2, 3, 4, and 6 failed to state an offense, as pepper spray gel is not a dangerous weapon under federal law. As a matter of law, pepper spray gel is not a dangerous weapon under the statute. See Federal Rules of Criminal Procedure 12B3BV. More, this and that and the other thing. Yeah, this video is getting too long, so I just got to spin through these things. But in conclusion, viewing the indictment, considering that all the facts alleged to be true, right? So here's what they want to do. They're saying all the facts are true. Viewing the indictment, considering all the facts alleged to be true, and considering the document as a whole of the indictment defective. The facts are true, but the document's defective. We agree to the facts. We agree to the fact that my client violated all those statutes you're talking about, but your indictment's defective. So go ahead and rewrite it again and come back and charge me again, because they can do supplemental. I think that's the right name, supplemental. Superseding, maybe a superseding indictments. So this doesn't do anything to help this guy get out of this case. It's just saying, hey, this is wrong, but we agree that all the facts you presented are correct. And that's the guy's attorney talking for him. Viewing the indictment, considering all the facts alleged to be true, we agree that my client did everything that you said. However, your document has some errors on it. Fix the document. Let's go ahead and do it again. Right. As a result of these defects, the indictment is constitutionally deficient and dismissal by this court is warranted. But they're just trying to get the indictment dismissed. So as a result of these defects, the indictment is an instrument facilitating malicious prosecution. That's what I say it is, right? That this was just a simulated legal process to facilitate a malicious prosecution. And malicious prosecutions are covered by an attorney's liability insurance policy. So ask for damages for the occurrence of an intentional tort. You need to claim that it was a malicious prosecution and you demand damages, which is what they call the compensation given under liability insurance for the occurrence of an intentional tort. And the occurrence amount is usually $1 million. So, right, the amount you're looking for is $1 million. As a insurance claim, not as a court case, but as a claim against the liability insurance policy of the prosecutor and against your attorneys, because they're all involved in it, right? This is a malicious prosecution that they're part of. So that's what's happened in America today. Hang on, this is not an order to dismiss a case, but it's a proposed order. Upon consideration, defendant's motion to dismiss the indictment as defective, it is hereby ordered, and the motion is granted, right? Dismiss the indictment. Not dismiss the case, not acquit the defendant, but just, fix your paperwork and come back and do it again. So order to dismiss the indictment, but not the case. Under Rule 7, it can still be tried by an information. Now, again, right, the complaint doesn't show that it was, the arrest warrant does not show that it was an indictment or an information, but it was a complaint. Well, that isn't what it said in the Federal Rules of Criminal Procedure. It said either by an indictment or by an information. So, never ending. Okay, I'm going to leave it there. I just wanted to do one more video to show that, hey, we're not done yet. They're still violating people's due process. So if you're a veteran or you're in the military and you're involved in one of these, start barking and say that you demand trial by court-martial. Because really, even veterans, I'm a veteran, you're a veteran. Veterans, we have not been released from the military. You do not have an order, an administrative order that releases you from the custody and control of the service, then you were not released from the service. You were just put in some kind of standby classification. Right? Your DD-214 is not an administrative order releasing you from the custody and control of the military. And under Title 10, United States Code, Section, I think it's 506. I believe it's 506. Where it talks about, once you enlist, if you're an enlistee, that you can be retained till 6 months after the war. And the United States is always at war. Right? It doesn't have to be called World War I or World War II or Civil War to be a war. Any armed conflict is a war. Right? The Defense Authorization Bill is evidence that we're at war. And if we're at war, then we're actually under the laws of war, not civil government. And that's why I'm trying to go to the military to get relief. So, we'll keep banging on the general's door until he answers. Okay. Y'all have a great day. See you.